Hi, it's Lorie Brown with yournurseattorney.com and empowerednurses.org, and welcome. Today we have a very special guest. I'm speaking with Larry Hansen of the Hansen Law Firm. Larry, welcome.
Hi, thanks.
Now, Larry's also an attorney, and in true transparency, I have to tell you, Larry was actually my boss years and years ago, and the best boss I ever had. And I know he wasn't expecting me to say that, but
I wasn't.
he's just fantastic, and I just think the world of him. He's now, I didn't do criminal law. We did personal injury and medical malpractice together. And so now Larry specializes in criminal law. So Larry, can you tell the audience a little bit about your practice?
Basically, my practice has been tailored down from the insurance defense days or the personal injury days to a solo firm. I prefer that. It allows me to interact with clients. It allows me to actually meet their needs and hopefully deliver what they're looking for.
So how did you get interested in that specialty?
That goes all the way back to college. When I was in college, my major was Public and Environmental Affairs, which is a long acronym or a long name for a degree that's mostly government work, but my concentration was criminal justice. So I got to do criminal justice all through college. Then when I entered the practice, since I didn't really know anybody, it was hard to get involved in that line of work. So I ended up in personal injury work until I finally had done it long enough that I got to say, I'd rather do what I want to do, and I became a criminal defense lawyer.
Yeah, and I think Larry and I practice very similar, that our clients come first. They're number one. We really are here to meet your needs. We do what we can, and we're real creative and try and do our best, what's best for our clients. So Larry, I understand you've represented a lot of nurses and healthcare providers.
A fair number.
Yeah. So what advice would you have to help nurses and other healthcare providers to prevent problems with the law?
Well, that's a pretty wide open question. What I would suggest to avoid problems with the law, be aware of your surroundings, be aware of what you're doing. Most people that I represent are good people that have made a mistake or had a lapse in judgment or got enrolled in the moment. So just be aware of your surroundings and govern yourself as if your mom were watching.
That's what I always say too, is, you know, there's cameras everywhere, and don't do anything if you don't want it to be filmed and on the news. So what if a nurse, would you say the predominant issue for nurses and other healthcare providers is DUI?
Not only just for nurses and healthcare providers. Operating while intoxicated is basically a crime of opinion that has really blown up in recent years. My last DUI trial, while we were selecting the jury, there were 13 members of the prospective jurors seated in the front row, and we typically ask if you've ever had a DUI or had any family member that's had a DUI, and this was by far the largest percentage. 8 of the 13 people had some exposure to DUI. So I think that's a demonstration of either ardent enforcement, which is over-criminalizing an event, and definitely much more public awareness, but for that many people to have that much of a contact with it raises some flags for me.
Yeah. Well, because in my experience with nurses coming to me, that's the number one thing that they have, because, you know, nurses and are generally, you know, good people, and I think that's probably the number one white-collar offense, right?
I think it's not only the number one white-collar offense, I think it's probably the number one offense in society. It takes normal law-abiding citizens and makes them criminals.
That's sad. So what should a nurse do if she gets pulled over?
A nurse, a doctor, or any other healthcare provider, or any person for that matter, if they get pulled over, you need to realize that when the officer approaches your car, he may already have the suspicion that this may be a DUI stop, depending on the time of day, especially 2 in the morning when the bars close. The officer is approaching probably with the thought that this could be a DUI and may be predisposed to observe clues that he may not readily observe if he weren't so predisposed. In other words, the interaction that you have with a police officer that day is entirely voluntary up to the point that you are placed in custody. So when you get involved in a DUI investigation and you hear the officer approach the vehicle and say, "Do you mind rolling your window down?" That's a request. You have the right to say, "No, I hear you fine." The officer can ask you for identifying information, and you provide your driver's license, registration, and maybe proof of insurance. But short of that, you're not required to roll the window down. The reason the officer wants the window rolled down, he wants to be able to get close to you to see if he can smell alcohol. That would be a reason for continuing on the investigation. If he can't smell alcohol, then there's no need to continue with the investigation. The other thing that's really interesting is alcohol is odorless. So it's not the alcohol that he smells, it's all the other stuff that goes inside the drink. And the presence of that smell doesn't mean that there is intoxication or impairment whatsoever. I can go on if you'd like.
Oh, this is interesting. But I just want to caution our viewers, we're not saying it's okay to drink and drive by any means, but you do have rights if you are stopped, right?
That's absolutely correct. What we say to jurors all the time is we are not interested in, at my firm or at Lorie's firm, in encouraging people to drive while impaired and endangering the public. Right. However, one alcoholic drink does not necessarily make you impaired, and probably doesn't. So it's not illegal to have a glass of wine with dinner and drive home. What it's illegal to do is drive while impaired, or it's illegal to drive with an alcohol concentration equivalent in excess of the legal limit. We were talking about rolling the window down. The next thing an officer typically asks you to do is, do you mind stepping out of the vehicle? I'd like to do a few tests to see if you're okay to drive. Again, that's completely voluntary on your part. Your response should be, "I'm sorry, officer, I don't consent to searches," because that's what he's asking you to do. He's asking you to waive your rights and consent to a search. By you performing these tests, of which, curiously, he hasn't told you what those tests are going to be, you expose yourself and create additional evidence that may be used against you. You have the right to remain silent in any criminal investigation. But since these are all voluntary statements at this point in time, it's not really a criminal investigation. It's a voluntary exchange between you and the officer. When the officer offers you a portable breath test, that's the little handheld one out on the street, you're not required to do that. Now, for me personally, one of the more disturbing parts is when I ask an officer, "Do you tell people that they're not required to do these tests?" Invariably, they always tell me no.
Right.
And I ask them, why not? The answer given to me in trial, in deposition, and in casual conversation is always, "because I don't have to." Well, they're right. They don't have to tell you that, and you don't have to do those tests.
So what happens if I say, I'm not going to consent to that?
Legally, nothing. The officer should move on. Now, I'm not here to tell you that in every instance, if you decline invitations by the police officer, you won't get arrested. You may. There may have been driving behavior that was inappropriate. You may have dropped your cell phone and grabbed for your cell phone and weaved. You may have had one drink and there is a smell of alcohol, but you're not impaired whatsoever. And let's say it's cold outside or windy. If you get outside and it's windy, there's going to be wind in your eyes. That's going to cause your eyes to tear. You now have red, watery eyes. You may stumble in the wind. You may have high heels on. Who knows? Or maybe you're like me and a few pounds overweight, and you're not going to do so well with these tests. So, even if you may end up having an unpleasant experience that night, it'd be better that you not create additional evidence to be used against you.
Oh, interesting. Well, thank you for sharing that.
Absolutely.
So we've had a number of cases lately where investigators or police officers or DEA agents come to a person's door. So what should they do in that instance?
Relative to the DEA agent, I'd like to specifically address that instance. There have been numerous reports in the news and in the media lately where physicians have been accused of over-prescribing or abusing their privileges and, according to the media, victimizing patients. I don't have an opinion either way. I'm not involved in those cases. But assuming that there are some semblance of truth to these allegations, when a nurse practitioner becomes involved, the DEA may show up at your home. The DEA may show up at work, and you'll be presented with a form. And that form says that I voluntarily surrender my licensure to prescribe medication. That's
right.
Don't sign that form. If you sign that form, it is tremendously difficult to reverse that process, and I call it put toothpaste back in the tube. It is so difficult to reverse that process. The form even says at the bottom, if you don't sign this form, it causes no hardship to you and will not result in any adverse consequences. So don't sign the form.
Do you have to talk to them?
Do you have to talk to the DEA agents?
Right.
You absolutely do not. If the DEA agents, just like the police officer on the street, say, I'd like to have a few moments of your time, I'm sorry, officers, I don't consent to searches, I don't make voluntary statements. Again, I don't consent to searches, and I don't make voluntary statements. You have the right to an attorney in any custodial or interrogative situation, and you don't have the obligation to give free testimony or free evidence against yourself or anyone for that matter. That doesn't mean resist law enforcement. That doesn't mean be difficult to get along with. But being overly nice sometimes does not serve you in this world.
And I know nurses are they are caregivers. They have such a good heart and they just want to be helpful. And of course, when a DEA agent or a police or whoever comes to your door, you want to help them. You want to give them information. And it's just natural. That's just who we are. But it could hurt you. So the reason why we want to bring this information to you today is so that you know your rights, so you know what to do in these situations, so that you can protect yourself. Because once the ball starts rolling, you could lose your license, your livelihood. We just want to let you know what your rights are so that you don't have these situations happen. So any other advice for nurses?
Just act like your mom's watching.
Okay. Well, we do have, if a nurse has a situation, a criminal matter, and it involves a Medicare or Medicaid patient, such as withholding medication or treatments from them, they could be reported to the Office of the Inspector General through the Medicare and Medicaid Department of the federal government. And if you are reported to them and are on their exclusion list, that means you can't participate in Medicare or Medicaid funding. So imagine trying to get a job where you can't take Medicare or Medicaid patients. So it's really important that when you have a criminal matter that if you are going to plead guilty to something, you want to make sure that you plead to something that isn't going to cause you to be on that list. Now, if you have a matter against your license, again, depending on the facts, that could cause you to be on the list as well. So, Larry, is there ways that you can help a person who, say, is accused from stealing drugs from a hospital to plead in a way that isn't going to affect their future ability to take Medicare or Medicaid patients?
It's important to remember that an accusation or a charge or a complaint is not a conviction. What the government is interested in doing is investigating claims and resolving those matters. It may not necessarily be to the lead charge or to the theft charge or to some form of neglect or taking medications from a patient. It could be that the government recognizes that a nurse practitioner or a nurse or a physician or whatever healthcare provider is a benefit to society, and that the greater good is to help the nurse practitioner or the nurse, the healthcare provider, deal with whatever problem may have prompted that situation. So maybe rehabilitation is the way to go. Maybe a deferral of prosecution. Maybe get the person into counseling and see how they do. Maybe have a heightened level of supervision that that gradually tails off. Most prosecutors are generally not interested in throwing professionals over a cliff. All of us in a professional life provide a benefit to our communities, and those benefits are not ignored. So rather than just throw yourself on a sword or throw yourself on the grenade, realize that you have value, realize that you provide benefit to society, and how can we use that benefit to assist you in a time of perhaps bad decision making. However, that does not mean, well, since I'm a healthcare provider, I can do anything that I want. Sometimes I have had healthcare providers who have a view that is not favored by society, and they've gone a little too far. So just keep in mind why you got into this field. You got into this field to make a difference. You got into this field to help people. Staying in that mindset greatly helps you when maybe a lapse in judgment occurred.
Yeah. And remember, the little lapse in judgment you had shouldn't overshadow your entire career.
Correct.
You have done so much good for your patients, and just this one little event shouldn't ruin everything for you. So don't let it define you, because you have so much more to give. And the last thing I want to mention is reporting. Now, it's my understanding that when some prosecutors find out you're a healthcare provider, part of the agreement is that you report to the board this criminal activity. And what I recommend is that you wait until the license renewal, because the license renewal, you're going to have to disclose it no matter what. And you're going to have to answer that question. Have you been arrested, convicted, or pled guilty to a crime? And even if you're on diversion, or that still means you've been convicted, but you're just not, but they're not going to be, I don't know the criminal word for it.
The way I define diversion is, okay, most prosecutors require you to admit the essential elements of the crime. In other words, admit that you did the act that would constitute a crime. However, the prosecution of that matter and the entering of a judgment of conviction is deferred or diverted from that path, pending a period of basically probation. And if that period of probation is completed successfully, the charges are then dismissed. However, what Lorie is referring to, I believe, is that you've now admitted the wrongdoing, which then can be used civilly in that licensure matter.
Exactly. So honesty is the best policy, and if you're not sure, it's better to report it and deal with it than to have a problem later down the road, because that's fraud and material misrepresentation in obtaining a license, and you don't want that on your record as well. And especially something so easy that the board can find out by looking at criminal records. They can find it out. So it's honesty is the best policy. So I have one more question about the new expungement law in Indiana. Could you tell our viewers a little bit about that?
Expungement law is Governor Pence's foray into, we are a strict state and we protect our citizens. However, we believe that a person should have a second chance, not a third, fourth, fifth, and sixth chance, but there would be an opportunity to clear off a criminal record. It depends on the level of offense. It depends on the type of offense. It also depends whether there was a conviction or not. If there is an arrest but no conviction, that arrest record can be expunged within 1 year, or excuse me, after 1 year of the date of the arrest. Misdemeanor conviction, I believe it's 5 years off the top of my head, and then so forth. The higher the level of offense, the longer the period of time. It's important that if you have any matter that you need to have expunged, that you are diligent in making sure that all of those matters were dealt with. If there were small matters in college or what have you, you should take care of this all at one time.
Because you only get one shot, right?
That's right.
Okay, so that's really important. If you do have criminal matters, you get one shot. So, but actually, the licensing board has changed the question, and it says except for expungements now. So if you have your matter expunged, it's a great idea it's a great way to take care of your criminal matter, because the board can't take that into consideration then. So anyways, Larry, how can people find you if they would like to talk to you about something?
My website is www.hansenlawllc.com. That's Hansen. I'm an attorney practicing in Noblesville. Google's a wonderful thing. You should be able to find me if you Google Hansen Law Firm or my name, Lawrence Hansen, or Larry, and put Noblesville in there. I'm sure you'll find me.
But Larry works all across the state, so wherever you are, Larry can help. And so thank you so much for being a guest, and I hope that our readers or listeners have enjoyed the content, and hopefully they don't have to use it, but we're here if you need it.
Well, thanks for having me.
Thank you.
All right.